for
Nsem-Pii will honor more, now Nsem so it is. Utie, now share on my YouTube channel.
Be the first to know Nsem-Pii TV.
News just in, and it's ene ukoko piemo ewo Accra High Court Registry na enyasem kotwa wo hokra the ambulance saga nyame yandoma wo china ena court etnase nene at the registry of the Accra High Court. Godfred Odame, Attorney General in the office. Richard Japa, third accused. Dr. Kesel Ato first accused. Sammy Gyamfi, NDC legal team. Nenye easy wo hono mokra. And the nekokosi wo Accra High Court Registry. Applications upon applications. And the way filing, now we filing. Where the two, now we the two, where the shoe, now we the shoe. And Nsem-Pii TV and Saka. Applications and then you're filing the registry of the Accra High Court and Yamiya Doma China Justice Efia Sewa Sarugutri, our Court of Appeal judge, no, and as a criminal trial or Tenaso as a High Court judge, a baby pin him, a man at Tenasi. Now, what determine said the case now, ABC Aquacusi. Now, I shall seem free a year or case after forcing a sugar because on and the home a dream near her and Umria, the only. Sammy Gyamfi and the NDC legal team no edi akwakoshim ewo court registry. Now, this is from lawyer Sammy Gyamfi Esquire. I say lawyers for Honorable Ato have filed a supplementary affidavit in support of the motion on notice for an order of mistrial, injunction, and or stay of proceedings in the ongoing ambulance case. And just say near mammy and son applications in son and honorable Ato pray justice if you are in the court to send number one, an order of mistrial. Now an order of mistrial in Nsem-Pii TV any lawyers video come on no much say an order of mistrial now Ato say court and granting. This is what it actually means. Now a mistrial occurs when a jury is unable to reach a verdict and there must be a new trial with a new jury, or there is a serious procedural error or misconduct that will result in an unfair trial and the judge adjourns the case without a decision on the merits of the case and awards a new trial. Now just say case Ato any NDC Richard Japa almost say Justice Efia Sewa Sarugutri application we can find last week concerning Niama Omofiu say Attorney General aya misconduct na prejudice case na tinebe ya asem no kra no trial de novo yen chance foforo judge oteso no yen sesa no fa new judgment na so yen constitute panel na omo beti asem no yen san ko chance yen ka asem no right from day one with a new bench, a new judge, a new prosecutor. 1% Godfred Odame and a better case so. I feel almost also a seeking an injunction on baby asema kwa kudun yenya ka kopem say be determined amata yewi. I feel so a stay of proceedings. I just say every other be a judge na aye biano yen twen so na all the accused persons jumedi bi a ompeso mu di bia na yenya omo na omunyi say jumedi na omo peso mu di no. Now, and at the office of the Attorney General, and also a dignity called Tum, or someone, Kurokran and Moody, on Penamamo, and Mamon filing applications with National Courtishia, more family disrupt to case. Now, the office of the Attorney General, and so at the application to now, also application, Moko 2, also Nsem-Pii only 2 journey, almost say. Affidavits filed in opposition to the applications before a high court in Accra that the accused persons are bent on using any means necessary, fair or foul, to abort their legitimate prosecution for crimes committed against the Republic must not be aided in that illegitimate endeavor through a grant of the instant application. Like I said, the Office of the Attorney General also says, "Some no can no more. Oma dibone." It was here no farmer so. ni sema o makai kan di ni nyina so bia nti ni kwan se court no yam ya adoma wo kina no ono so ejinem. Now the office of the Attorney General also affidavit in opposition no, it avers that it is in the public interest that the case be brought to a firm conclusion based on the credible evidence before the court. In the particular case of Dr. Forsen, the affidavit in opposition argues that continuing his prosecution to its logical conclusion will uphold the principle of equality of all persons before the law and defeat the perception that the powerful and politically connected can get away with crimes on account of undue pressure and false allegations. As I said, the Office of the Attorney General still maintains, say, the sitting trial judge has already established a prima facie case against Ato Forsen, Richard Japa. So, omo Nsem also be yano. Ninti no file a statement of no case or bototuni no. Say evidence here, the arbitral court no dia dance here. Say letters of credit are issue here. Car somebody buy say ambulance. A rejecting or Ministry of Health. It is clear say there has been a certain kind of loss be to the Republic of Ghana. To the Office of the Attorney General in their affidavit in opposition and was stating it clear. Says a court no etie in Nsem-Pii Sammy Gyamfi Ato Forsen lawyers say they should conduct a mistrial. Omon chance here for omon fa injunction to so stay proceedings na. The Rema Ghana for adwini nyina yom say if you are connected politically there any one sem intimidate say the Mahama de betu dwa say omunya Ato Forsen case no. Otherwise the minority will not comply in the business of government no. And I just say yeah you know correct. So the trial judge, Justice Efiase Wasaributwi, the office of the Attorney General also affidavit or file and said she should not accept a yes applications here on more day abe. Now, same way now the Aquaco Faba is a leak tape recordings and semia. The NGC is alleging say the Attorney General and Richard Japa Edin Komo say on Nsem-Pii to implicate Ato Forsen in finding Congo Tum into professional misconduct. Criminal trial ekoso and Attorney General edin ho for nti wasay asem ni now lawyers from the opposite side and the man to Nsem-Pii Professor Kwame Jan a lawyer ni papa brenim ni kesiye pa and one lawyer from the NDC side lawyer Pia omo nyina adwena kwadwen kromo on this same issue. Professor Kwame Jan states categorically clear say the office of the Attorney General enye boni bia so na Richard Japa din komo and komodi ne ekoso there was nothing in the shape of implication and no force Richard Japa say won ka bibi emfentia iura Ato Forsen. Now lawyer Pia so on the NDC side no so kire say ono no de ade we ya ono angasa ne party for you no hu nyina so bi omwo because tape na mo de aba no one afei na mo de court it is going to be tested on two things based on relevance. How relevant is this audio recording in the case before the court now? Ebeka ya no na Justice Efiase Wasaributwi so no de omke kan de onte niam e won ani mo court ho and odi beye adwuma. That is number one. Number two, also say it is going to also be tested on admissibility. Admissibility na se abegia tomu a just say I pass it through certain tests bi I just ya hwehwem ehunu say ampa tape no original. In the election petition case, MPP presented here over 11,000 pin sheets. On the case of admissibility, the test for admissibility, no, my KPMG audit, I'm a yibe free mo, and sana the catch, no, yababe admitted a usual court. In the same way, that audio must be tested on the basis of admissibility. And to win yes, I am a then I'll file supplementary affidavit application, say young conducting mistrial, young granting injunction, and stay of proceedings. Tomorrow promises to be a very, very, very eventful day in this ambulance case trial. Now, when we call in lawyer see or manu this concerning this new development in the Ato Forsen case.
Investigating a crime or suspect that a crime may be committed, they would go to a court of competent jurisdiction and seek leave of the court and obtain same and tap into your communications with leave of a court of competent jurisdiction. In that situation, admissibility should not be a problem. In other situations, our law, if you go back to our evidence decree, the evidence decree, which is now the Evidence Act, because of the Statute Law Revision Commissioners Act, is one of the best pieces of evidence decrees in the world, or evidence legislations in the world, because the drafters, led by a late Court of Appeal justice called Justice Ofori-Boateng, famous judge, they studied the evidence laws of almost every civilized jurisdiction and tried to find out what is the best practice before they created our own system. Now, in American jurisprudence, there's a principle which is known as the fruit of the poisonous tree. It's one of the principles that applies in the law of evidence, which says that where a tree is poisoned, the fruits of the tree are also deemed to be poisoned. In non-legal format, it means that if evidence has been collected in a way as constitutes a violation of law or rights recognized by law, the evidence will not be admitted to establish the guilt of an accused person. But you made a point. There are circumstances under which that evidence may be admitted. And in fact, in the case of Raphael Kubaji versus Michael Yeboah and two others, the Supreme Court set out the parameters of admissibility and made provision for the evidence to be considered on its own merit, depending upon the gravity of the offense that is on the table. So the courts have a way of dealing with it. But the general principle is that where the tree is poisoned, the fruits are also poisoned. That's the general principle. But like all general principles, there are exceptions. There are exceptions.
Right.
But the exceptions don't become the rule. They remain exceptions.
Talking about these exceptions, are you able to elaborate further whether there are legal distinctions between recording a private citizen and recording a public official, as has happened?
Honestly, our laws, from the constitutional framework through statute and case law, our laws have not distinguished between how you treat conversation with a public official and how you treat conversation with a private individual. Now, let me sound a caveat here. When it comes to the law on libel and slander, generally, the law on defamation, the courts expect public officers to have thicker skins. In other words, if you're a public officer and I say something defamatory, so to speak, about you, the court would expect that the level of the standard which is required to satisfy proof of defamation when the allegation is about a public figure is different from when it is about a normal citizen. Because the court says that once you have come into the public arena, you must be prepared to take some heat. Because if you come to the market, you are going to be treated like any player on the market. So that's one slight distinction. But when it comes to recording without consent, our laws do not draw a line between when you record a private citizen versus when you record a public official. The standard, as the law is now, is the same.
The laws are indeed available, and since they are an enforcement on that, on the flip side, will also come into the limelight. And I will want to find out from you, Professor Jan, that what could be the potential legal consequences for individuals who make use of secret recordings without consent, as again has happened presently?
The interesting thing is that Article 18, which provides your right to privacy, and Article 21, Clause 1, A and B are not penal provisions. So the constitutional provisions don't have penalties attached. But the statutory provisions are in a different realm. And remember, you, the person whose privacy have been breached, can also have recourse to the civil law.
So you mean a public official can take legal action against him being secretly recorded?
And a private citizen can also do the same. But you see, most of the time, we run with the information. So we take very little time to look at the illegalities involved in the recording. There's a gentleman, I respect him a lot. He's called Nsem-Pii. He just has been employed at the University of Ghana School of Law. So he's my colleague at the University of Ghana School of Law. Around September, when the last year, when the IGP recording thing came up, he was one of the lawyers who came out very strongly on his page and was very categorical that the recording was illegal and criminal. And he didn't mince words at all. I've not heard him on this one, whether he stands by the same position. But previously, he was one of the lawyers who came out forthright to defend, to kind of condemn that action on the basis of the method by which the recording was done, the breach of privacy and our laws.
Professor Kwame Jan, and my earlier question to which I asked about public officials taking action against those who secretly record them, I was hoping I could also hear you speak to whether there are typical remedies available. I'm glad you tried to scratch the surface on that. But again, you did argue that on the flip side, either a private citizen or public official can take whoever secretly recorded them to court. But can you expand these typical remedies that could be available for any of these individuals who catch themselves being secretly recorded?
So if you file a complaint with the police, they will conduct their investigations, and that will be a criminal proceeding at the instance of the Republic of Ghana. If you decide to go on the other side, it means you are going to a civil court, issue a writ, and proceed accordingly for violation of your privacy. Now, once you do that, you are going to make a claim for compensation. Now, for the criminal part, it is not for compensation. It is the state which is going to sanction that person for breach of the state's law. So the title of that matter will be the Republic versus the individual who did the recording. The title of the other matter, the civil matter, would be the person who was recorded versus the person who did the recording. The outcomes and the expectations.
Nsem-Pii TV nie